Right, good evening, ladies and gentlemen. My name is Stephen Frost. I'm a director of the British Chamber of Commerce in Thailand and chairman of the Legal and Taxation Subcommittee. Our distinguished speaker this evening is Matthew Lloyd. He's going to talk to you about a very important topic, drafting wills. Just to go back in a little more detail on his background, Matthew is the managing director of professional wills in Hong Kong, and he manages the running of the office there. He's a member of the Institute of Professional Will Writers in the UK and is a member of STEP, S-T-E-P, which is the Society of Trust and Estate Practitioners. Matthew is originally from the UK and he's worked in the finance and estate planning sector for many, many years. He moved to Hong Kong in 2001 and has been drafting wills and advising clients on their estate planning throughout Asia since then. Matthew, amongst other things this evening, will be talking about some case studies that he's been involved in relating to UK inheritance tax planning and domicile issues, including what is your domicile and where is your domicile? Are your worldwide assets subject to inheritance tax? Common misconceptions concerning the notion of domicile in the UK and inheritance tax in the UK itself. Ladies and gentlemen, before we start, could you please switch off your mobile phones so that our speaker is not interrupted in his presentation this evening? And can we have a nice warm welcome for our distinguished speaker, Matthew Lloyd.
Thanks, Stephen. Thanks for coming, everyone. We were just saying we're encouraged that there's so many people turn up to this sort of thing because it's not the most interesting, perhaps, or exciting topic, but I think the lure of the free drink often helps. So you must try and take advantage of that. As Stephen said, we're going to try and talk about a couple of things today. There's two sort of halves to the talk. One is general basics about will writing, why you should have a will, what happens if there's no will, and then the other part is really to talk about more UK related issues such as domicile, UK inheritance tax, and as Stephen said, perhaps some common misconceptions about whether your assets are subject to tax. I think at this point I'm supposed to say we're not tax advisors in what we do. We're humble will writers, and in writing wills we often touch on, I suppose, a number of related areas of people's estate planning. And we talk about wills and estate planning, and people say, what's estate planning? And it's your will, it's your trust, it's your financial planning, your business succession planning, your life insurance, pensions, and I think all of that combined is your overall estate planning. So when we write wills to clients, we sort of talk about all of those related issues. Writing the will is sometimes the most simple part of that. The rest is an ongoing process. So it creates a few interesting topics, hopefully, as this week it is. Okay, so in summary of what we're going to talk about, when I do these types of talks, people often say, do I actually need a will? Because they assume, sometimes wrongly, that if they die, when they die, their assets are going to pass to husband, wife, partner, children, and that might well be quite okay for them, they might be happy with that. So there's sometimes a thought, perhaps I don't need a will, and whatever the law is, that will be sufficient for me. So we'll talk about intestacy, which is the phrase that applies if you die with no will, you die intestate. And then some common appointments in wills. We talk about guardianship for children. So anyone here who's got young children, I think in Thailand the age of majority is 20, somebody was telling me, not 18. So if parents die and children are still below that age, you can appoint, and you should appoint, I suppose, a new legal guardian for your children. So that's always written in a will. And then, of course, related to that, you then decide who gets the money in the will. You want to pass on money to those that you love, husband, wife, partner, children, and so on. And so that's obviously the main thing that people consider when they write a will, is actually who gets the assets and how they're passed on. I was talking to a couple of people earlier and a client that I saw the other day, and they've got quite a complex set of affairs. They've got, I think, connections to 5 different countries: property, banking, pensions, investments in 5 different countries. And I think these days that's the norm. We get very few people who've got assets in just 1 or 2 places, and so when people have sort of convinced themselves they need a will, it's then thinking, where are their assets located? Is 1 will sufficient? Should there be separate wills? And so something that we specialise in is sometimes the idea of having multiple wills, and actually having wills written for jurisdictions where you've got main banking, properties and so on. So when we've talked about that, I'm going to, as I say, talk about inheritance tax, UK connections, domicile, and how that fits into estate planning. There's a few things that might fall outside of wills if you die: life insurance, pension benefits, jointly held properties, banking, those types of things, which people often are not aware of, but some of your assets don't require a will after you've died. Oh gosh, we can really depress you then. Then you talk about losing mental capacity. So the will takes effect when you've died. Before dying, you may lose capacity, and so that can be a problem, and there's documents you can put in place so that somebody can actually access your banking and pay the bills, keep things going until you recover, or if you do eventually die. That's when the will takes over. Oh, and then finally, you can do a living will then. So people often ask us to write in the will that they don't want to be kept alive on life support machines, and can you just write in something that says turn off the life support if they're in a coma or in a vegetative state or something. And you can write that in the will, but there's no point because the will only takes effect when you have died, so that's not the place to write those wishes. So you need a separate document if you've got strong thoughts about that, which is a living will, sometimes known as an advanced medical directive. So that's where you can make your end-of-life wishes known to your doctors. So we do that as well. I should just say, as we go through, it's very boring for you to sit and listen to me talk for an hour. So if there's any questions as we go through, I'm happy to take questions. There's going to be time at the end for questions. I'll no doubt hang around at the end as well. So if anyone's got any questions at any point, then just put your hand up. We find it's a bit more interesting in that way. No questions so far?
Just to state that I'm depressed.
Yes. Well, you're sitting closest to the alcohol, so. It's a dying business. Okay, so here we go. Why write a will? As I say, if you don't have a will, you die what we call intestate, and that basically means where you've got assets located. If you don't have a will, the law of the country where the assets are located would dictate where the money goes and who gets control and access to the funds. So needless to say, each country has a different set of laws which would say where the funds go to. It's not always to husband, wife or to children. Various other family members often benefit. So if you die without a will, we say there, so you lose control over your estate. You've got no control as to who gets the money, and the people that it would end up with might well not be the people you've chosen. I'll come back to executors and guardians, but the third one down there says you can't choose the age of inheritance for children. So again, even if the intestacy law said everything would go to your 2 or 3 young children, people say that's fine, I'm happy with that, don't need a will. You probably don't want your children getting the money when they're 18 or 20 in Thailand perhaps, when they're young and irresponsible. And so, although the funds might go to them, they probably get it at too young an age for them to do anything sensible with it. So, when you write a will, you would choose the age that the children would get access to the money. Somebody's appointed to look after the money on their behalf. And those appointments are often executors and trustees of the will. So if you die, somebody's got to pay off your credit cards, cancel the bills, close down the bank account, sell your property, and do a whole load of administrative things, which is the probate of your affairs. So again, if you don't have a will, you don't choose who those people might be, and you might have 1 or 2 people in that role. So somebody would apply after you've died to access your affairs. We say that you can't gift your personal items, and again, the sentimental items are often more valuable than the money in the bank, and so again, there's no control over what happens to those assets. The final one is there's no control over what happens to you. I think that means, well, it does mean what happens to your body if you're buried or cremated. Don't be too depressed at the back. You can write in a will where you want to be buried, cremated, funeral wishes, that sort of thing. And again, if the will is silent on that, those left behind often don't know what the wishes were and what the intention was. So I think the idea is to say that if you don't have a will, yes, the assets may go to the people you choose, but you probably haven't got people in there to look after them, oversee them. And I missed out the most important one. Nobody is then appointed as guardians of young children. So then the court would actually make a decision as to who would be the guardians of the kids. And again, that might well not be the person that you would have chosen. You have to hope somebody applies to be guardians, otherwise that's also a problem. I'm not sure what I'm saying.
How long does that process take?
Which process?
The appointment of guardian.
Oh, right. Yeah, I think it depends on different countries. If somebody dies and there's no will and there's no legal appointment of guardian, then there's a process for family members to apply to the family courts to apply for guardianship of the kids. And so you can imagine that the length of time that might take. It might take a number of months, particularly if you've got 2 or 3 people applying and there's contention over who should be the guardian and who's most suitable.
Where are the kids?
Yeah, good question. They're in a small room downstairs. Well, prior to that, the other concern, I should go back one step, because not just the appointment of permanent guardians, actually, when we see clients here or in Hong Kong or Singapore or elsewhere in the region, a lot of clients are expats and they're away from home. They've got no family nearby. Their brothers and sisters and parents are back in their home countries. And so actually, it's the appointment of temporary guardians that's the real concern for people, because if husband and wife both die, the kids are at home with helpers and nannies perhaps, even if you've got a will appointing the brother as the guardian, it might take them 2 or 3 days to get over here or to Hong Kong or Singapore or wherever, to actually pick up the kids and look after them. So appointing a neighbour or friend as temporary guardian is probably the most important thing people do when there's no family in the country they're living. So in the meantime, what happens to the kids? The kids are then not taken off by the authorities and looked after until a court appoints a guardian. But authorities are generally happy to leave kids with family members until an appointment, a formal appointment is made. You know, the authorities don't want to be looking after your horrible kids for 6 months until the courts figure out who the guardian is. So it's not a case that the children are looked after by strangers, but a process might take a number of weeks or months, as you might imagine. Somebody's nodding at the back, so I think they agree, so that's good.
Can I ask you a question about how do people that are appointed these things know where the will is? So say there's husband and wife and they've both got a copy, they're both copied. How do you find the will?
Yeah, good question. Yeah, we've thought about that, but it's a good question. We have half a dozen safes in our office in Hong Kong. So if you come and write a will, we would recommend that we store your wills in the safe.
But then that means I've got to be nice to you for the rest of my life.
You've got to pay us a yearly fee, so absolutely.
Now, if you that's business, that's actually not wills, is it?
What it is, that's right. But if you die, you're right, we don't know if you've died, and so we can't call up your brother and give them the will. So if you write a will and when you sign it, we would give you a letter to give to your executor, whether that's your brother or sister or whoever, notifying them that you've done a will and it's in a safe and they know where it is. So that if you die, of course your brother knows that you've died, he has to then contact us, get the will, our job is release the will to the named executor.
So it's still a traceability issue. You could say you died with your brother, the same issue applies.
Yeah, but when we've written your will, we say, who's your executor, your brother, and then we say, if he dies before you, who's the alternative?
So either way, there's a benefit business for you.
Great business. Yeah. Although I think on the storage, it's, when people write the will, it's written, it's signed, it's in the safe. You can't forget about a will, because over the next few years, things change. People get married, divorced, acquire assets, leave, go to another country. Most of those things might require you to update and change your will. So we really work with a lot of our clients to keep the wills up to date, and we write to you. If you store your will in our safe, we'd write to you annually with the bill. But it's as a reminder for you to
Pay the bill.
you don't pay for a couple of years. But it's a reminder for you to think about your wills and say, actually, yeah, I've gone and bought a house somewhere, and I'm moving next year to somewhere, and what does that mean? So we work with clients to review wills and update them and keep them current, which is important. Yeah.
Is there, in that instance, is there any way of kind of registering a will with, say, the UK government, for instance? So if you did die over here and your passport goes to the British Embassy, that it's kind of pulled out that way, no?
No, correct. Well, in the UK, not really. In some of the European countries, they have central registers of wills, and it's a formality in some places to register a will with the authorities, which is a good idea, because if somebody dies, it's easy to see whether there's a will. Most countries don't have that requirement, and so it's really up to you to notify the people that you've chosen in the will where your will is. Whether it's with us in our safe or in the bedroom drawer at home, they need to know where they originally stored. That's the main thing. Okay, who should write your wills? Oh dear. We talk a little bit about how to write wills, and we say they can do it yourself. I put that on there to make you understand that you can write your own will, and you can sign it and witness it, and it's a valid legal document. Of course, we don't recommend you do that. Most people assume you have to go and see a lawyer to write a will, which of course you can. In those scenarios I talked about where clients have got assets in 3, 4, 5 countries, if you're going to see your Thai lawyer, they can do a Thai will. If you're going to see a lawyer in the UK, they can do a UK will. I shouldn't say UK, England and Wales, Scotland is different for wills, of course. And so they're not really able to advise on assets that you hold in other countries. So they can write the will for England, but they can't write your Thai will, and you wouldn't perhaps expect them to be able to. So lawyers are restricted to giving advice and doing work in the country that they're licensed to practice. So the difference with us is that I'm not a lawyer, don't particularly have a legal background, so we're a will writing company who can write wills for most places that we come across, provided they're written in accordance with the law of that place. And of course there's the odd place we can't write wills for, which require different formalities.
Like where?
Sorry?
Like where?
Like where? Brazil. Sorry, not Brazil. Mexico, you need a thumbprint on your will and various provisions. Macau needs to be in Chinese or Portuguese generally. Indonesia should be done by an Indonesian notary. Those types of places. But if you think of most of the common law countries, Hong Kong, UK, Singapore, Australia, the US, Canada, New Zealand, those types of places have very similar formalities for wills, and they're relatively straightforward to sign, witness, and for them to be valid. Okay, so there's a bit about us. Our physical office, our only physical office is in Hong Kong, and we've been there since 2006. We've got serviced offices here and a few other places in the region, so over the years clients have left Hong Kong and they've moved in the region. And we get new clients and new introductions in various places, so we're happy to have a jolly, a working holiday, a business trip or whatever it is, and to come and see people and to do review meetings and update wills and that sort of thing. So we're able to do really exactly the same as what we do in Hong Kong here and in most other places in the region or around the world actually. And as I say, what we really specialise in is the idea of multiple wills which we're able to write for people where they've got connections to major countries. And as I say, we provide storage of wills and updates and all of those things. I've talked a bit about guardianship then, so the most important thing in the will is legal guardians for children, temporary guardians of the children until family arrive to pick them up. There's questions earlier, children taken into state care, so we get calls all the time from people saying, I've heard that the kids, if we both die, the kids are taken off by the authorities, and somebody said they're taken to an orphanage. It's great for business, these types of stories, I don't know where they come from. But I'm not sure it's quite that serious, but certainly if you've got no appointment of guardian, it's unclear where the children would go, and so choosing that person is normally the priority. Any questions on guardianship? And then, as I say, the other appointment, once you've appointed a guardian the guardian has legal parental responsibility for your kids after you've died until they're adults, essentially. The other important appointment then is the executor and trustee of the will. So those are people who, and it might well be the same person as the guardian.
Sorry, can I ask you a question? Is it the will the only document where you can specify the guardian for your children?
No, it's not. No, you can do, in a lot of places, you can do a deed of appointment of guardian. So you might have a simple document where you and your wife, for example, would sign a document appointing somebody as the guardian, and it would be signed and witnessed in a certain way. And that's also a perfectly legitimate way of appointing guardians for children.
Because that would be easier than changing your will every time you move house. Or
yeah, quite possibly. Yeah, quite possibly. I think we get some calls from people and they say, I don't want to write a will, I just want to appoint the guardians for kids. And we've written a will before just appointing guardians. I think if you did that deed, when the deed has to change, you still have to re-sign it and have it re-witnessed, perhaps quite similar to how you'd redo a will.
So it's the same thing.
Yeah, I think so. And I think if people say, I just need guardians for the kids, we then say, well, that's okay, but what about executors? What about trustees? How do you give the money to the children? Who's going to look after it? What are the considerations? And that's everything that then is included in the will. And so I think it's okay just to appoint guardians, it's better than nothing, but logically you would cover those other provisions as well, I guess. And so, as we say, if the children are still children when you die, then trustees are normally appointed in the will to look after the money on behalf of the kids as they're growing up, and they would give money to the guardians to support the kids, pay for schooling and spending money, that type of thing. And that continues until the age that you choose in a will, when the children would get the money, 25, 30, and anything beyond that is probably a sensible choice. You know. But so a trustee is that person, or probably 2 or 3 people, who would look after your estate on behalf of beneficiaries long term until the beneficiary is an adult. And of course all of this is quite difficult for because people say who should be the executor and the trustee. Most people appoint their husband and wife, and if they both die they appoint a brother and sister or a parent or a close friend, which is okay. Realistically, if you die and you've got money in 3 or 4 countries, it's such a big job for the brother or sister to actually understand what's involved in sorting things out. So it's quite common for them to appoint a probate lawyer and somebody who would actually specialise in sorting out your affairs after you've died, and your family can sort of oversee that process, which normally works fine. Assets not covered by wills. Yeah, I touched on this. A lot of people, I saw a client the other day and he got a sizable life insurance policy, and he got somebody named on there as a beneficiary who he didn't want to include in his will. And he was writing a will to give his money to other people. And so he was quite happy with that. He thought that was fine. But he didn't realise that if he dies, the nomination of beneficiary on his policy would override the will. So although his will says, I give everything to my brother and sister, his life insurance policy still had his ex-wife named. So if he died, the ex-wife still gets the $2 million or whatever it was, and his brother and sister get the money in the bank that's covered by the will. So things like life insurance, for those of you who are employed and have death in service benefits with your employer, and for pension benefits and for some types of long-term investments, most of those types of policies allow you to name a beneficiary. So if you do that, you have to make sure you get the right person named, because if you die, the insurance company or the investment company will pay the money to the named person. That doesn't go into your will, it goes to whoever you've named on the policy. Similarly, a lot of people have got joint accounts, and there's always arguments about joint accounts. People say if somebody dies, the account's frozen and it's problematic for the husband or wife left behind, and they wonder why that is. But actually, unless your account is a true joint account, your assets will freeze if you die. I'll give you an example. I got married a few years ago, and when I got married I had my own bank account, and I added my wife as a signatory. So now we sort of treat that as a joint bank account. But if I die, it's actually my account, and it would freeze, and it would go through my will, and it would go to my son, not my wife. It would go to my wife. But it would be delayed, and it would be frozen until it goes through the probate and goes to my wife. If you've got a joint bank account where we've both gone to the bank, opened up the account with our passports, and it's a joint account, if I die, the account would default to the other legal owner by the way that it's legally owned. So again, people assume sometimes that they've got jointly held assets, but actually it might not be the case. It's the same for supplementary credit cards, for example. So we get clients who die sometimes at the bank, not very often, and you know they don't know that they're a supplementary credit card holder. The credit card's cancelled. They don't know that the joint account isn't a joint account and it's a single account, and there's no access to funds because very often, for various reasons, more money is in one person's name than the other person. So understanding those sort of practical issues is important. It doesn't affect how we write wills because you don't need to name the assets in the will. Typically, you might say, I give my estate to my wife, my estate to my children. We don't name the bank accounts or the investments or the property. So if they change, you don't need to change the wills necessarily.
Does that apply to joint ownership of real estate?
Well, good questions. That's the next one. So joint property, it depends whether it's joint tenants or tenants in common. So if you've got a couple and they buy the family home in joint names, it's common that they would own it as joint tenants. And that means if one person dies, the property defaults to the other joint legal owner. And that doesn't go into the will, doesn't go through the probate. And that would normally be the intention, that it would go to the other person. We have plenty of clients who bought property as a bit of an investment with their brothers and sisters and friends, and so they own it jointly. Now, if I bought a property with my friend as an investment, if I died, I wouldn't want my half to go to my friend. I'd want to give my half to my wife and children. So then I should own it as tenants in common, which means I own half and my friend owns half, and if I die, I can give my half according to my will.
How about estate duty liability, say if it's in the UK?
Well, I'll come on to that. But if it's a property in the UK, it's almost certainly subject to UK inheritance tax.
Half of it or whatever.
Yeah, your interest in the property would be. Yeah. So again, understand. We have lots of people who, people come in and they've written their own will, or they've got a very simple one-page will. I remember a lady who got a will saying that she gave her property to her brother. When she was updating the will, she wanted the same thing in the new will. And so we do a property search on the property because we have to make sure this lady owns the property and she can give it away in her will. Well, it turns out she owned it with her sister as joint tenants. So I said, we can't write this in the will because if you die, your share of the property goes to your sister because she's the other owner. It can't go to your brother. And if we'd written it like that, we would have been in trouble as and when he died because the brother wouldn't have received the property. So as will writers, we're not always interested in how much money people have got, but we're interested to know where your assets are, how they're legally owned, to make sure when you do die, they can be passed on to the people that you want them to be without any claims and problems and that sort of thing.
So what did you do there where what you wanted you couldn't fulfill?
Well, we did. So when you own a property as joint tenants, you can do what we call a severance of joint tenancy, which is quite easy in a lot of countries. So if you are a joint owner, you can sever the joint tenancy with quite a simple document, which makes the property held as tenants in common. And then if you die, you can give away your share via the will. So it is possible to change that. Of course, there might be considerations of costs involved in doing that, stamp duty and that sort of thing, but you can do that.
Just before you move on, talk about investments. What's the clarification there? You don't, stocks and shares, presumably must be covered in a will.
Yes, there would be. The type of investments...
You're saying they're not covered by will?
Some of them, so it depends. So to clarify, 5 or 6 years ago I set up one of these long-term savings plans which you pay a few $1,000s a month for 20 years and you're supposed to get some money back at the end of it, which is fine. So it's...
Lots of those around here.
There are lots of those around here. and they work fine, and those are the types of policies where it's primarily an investment, a long-term savings plan. But if you died after 5 years, that policy would normally allow you to name a beneficiary. And the fund value at the time would be paid by the company to the named person. So those types of longer-term regular savings plans are sometimes allow you to name a beneficiary. You're right, if you own shares in your name in HSBC and you die, those are your assets and they'd go into your will. So, yeah, depending on the nature of the investment. Sometimes.
So shares, bonds, the normal.
Yeah, they would all be your assets and they'd be part of your will if you don't. You can choose who they'd go to.
Yeah, thank you.
Okay, any more? Okay. And then, so that sort of relates on to the last one, the claims on your estate, disappointed beneficiary. So the lady who wanted to give away, or was it the guy, I can't remember, the guy who wanted to give away their share in the property, and they couldn't, if we'd written the will as they'd instructed us to, and then when they died, the sibling that didn't get the property would have been what we call a disappointed beneficiary. They haven't got their gift as per the will. The will writers are sued for incompetence because we didn't check whether this person was legally allowed to give away the property. So that's when you sort of start to hear about these claims on estates and people who are upset because they've been excluded or something hasn't quite happened as they may have expected. That's when it gets quite interesting, of course. But domicile.
Oh.
Oh.
No.
Yes, quite. Has anybody got a will here? Hands up if you've got a will. Anybody? Has anybody got more than one will? Oh, very good. Oh, very good. Excellent planning. You're our clients, aren't you? So we talk a lot about, I think when we write wills, generally not just for people with UK connections, but actually anyone who's got assets in a number of countries. I think as will writers, we can't really write wills without understanding where somebody's domiciled. That affects the structure of wills, the formalities for wills, and it can also affect which of your assets are covered by wills, and it can also affect the distribution, the law which applies to those assets. So the domicile is key, not just from a UK tax point of view, but also generally in the structure of multiple wills. And if the structure isn't quite right, it can also provide, or it can really result in conflict and confusion after you've passed away. So we talk about domicile generally with most clients where we're writing multiple wills to understand the structure of the wills. Now, for those people with UK connections, the domicile is that much more important, and there's 3 types of domicile. So I was born in the UK, and so I had a domicile of origin at birth, because my father was also born in the UK, and you acquire at birth your domicile of origin from your father. And that's normally fairly clear for most people. If they're born in the UK and sort of grew up there, their domicile of origin would be the UK at birth. You can acquire a domicile of dependency, and we have a lot of clients who are born in various jurisdictions around the world, but then they acquire from their parents their domicile of dependency based on where their family were based and where they grew up at the time. Later on in life, when you've left the country of your original domicile, you may have the option of choosing your own domicile, and there's a concept of your domicile of choice. So if you take me as an example, I grew up in the UK, I left, and then I've been in Hong Kong for almost 18 years. And so my choice of domicile now is Hong Kong, and I see that as my home. I've got no plans to go back to the UK. I feel like I'm connected in Hong Kong. I've got no property back in the UK, and I would say my choice of domicile is Hong Kong. The problem with domicile is you don't find out where you're domiciled till after you've died. So that's a real problem. You'll never really know where you'll be deemed to be domiciled. And that's important for tax reasons, which I'll explain.
So who decides that?
The UK tax authorities, so HMRC, would make a ruling as to where they decided that you were deemed to be domiciled when you died. And it would either be your domicile of origin, if that hadn't changed, or if you had changed your domicile and they were satisfied that you'd established a new home and you were living there and you intended to stay there, they might agree with your domicile of choice. Might. And that would be an argument between the UK tax authorities and your executors in your will.
But I assume if you've got assets in the UK, then that rules that out totally.
But possibly, I'll come on to that, but possibly, yeah. A lot of people will say that we get many clients in the region who've been non-resident in the UK for many years. I've met a client over here who's been in Hong Kong for 20 years. He's now been in Thailand for 8 years. And so he said, I've been away for almost 30 years. How can I be domiciled in the UK still? We get lots of clients who've done 3 years in Hong Kong, 2 years in Singapore, 3 years in Japan, back in Hong Kong for 2 years. And they've been non-resident quite clearly for 10, 15, 20 years. But they probably haven't ever acquired a new domicile because they've done a couple of years here, there, and they've not really established a new home. So although they've been non-resident for many years, they perhaps have never relinquished their domicile of origin.
How do you change it? If you choose to change it and say you want a new domicile,
Yeah.
who gives you the permission to say I'm domiciled somewhere else?
Well, you'd argue that it's your choice.
Yeah.
You have a choice of domicile. And so then people...
Can you tell the tax inspector, sorry,
you
we
can.
don't want anything about you, we're domiciled
Yeah.
somewhere else?
You can, you should do. Yeah, there's a few things you can do. It relates to wills because the will is one of the few documents where you can make a statement of where you consider your domicile to be. So there's two things you should do in a will. And I'll come on to the other one later on, which is quite unexpected. But you should write in a will where you consider your choice of domicile to be. And we'd have that written in all wills that we prepare. So you can choose. Whether it's agreed and upheld after you've died is quite another matter. But you can choose where you consider your domicile to be. And there's a few other things and places where you can make that statement known, actually. So why is this important? And what impact does it have on your tax situation after you've died?
You said 2 things.
Yeah, go on.
You said 2 things.
Oh, 2 things?
Yeah, you said you should say in your will and...
Yeah, there is. It's at the end here, but I'll tell you now. No, I'll tell you now. So you write in the will, I'm domiciled in Hong Kong, Thailand, Singapore, wherever it is. When we see clients, the final question we ask them, oh, he's gone, the guy at the back, it was too much for him, is where do you want to be buried or cremated?
Oh.
Now, a lot of people come in and they've got an existing will and it says, I'd like to be buried in England in the family plot, and they don't think anything more about it. In the UK, there's case law which says if you've written that in your will, if you've got in the will, I want to be buried or cremated in the UK, you're automatically UK domiciled. Yeah, exactly. And they've got you for the tax. And I haven't explained why that's important, but they've got you for the tax. I'll
But
explain
wouldn't the
why.
local jurisdiction contest that? So if I put that in my will that I died in Thailand,
Yeah.
Thailand might want to tax my estate and say, sorry UK, he died here, he lived here long time.
Yeah, and there's 5% inheritance tax now in Thailand, which was introduced a few years ago. But the main concern is 40% tax in the UK.
No, I understand that, but I'm saying that it would be a fight between the 2 jurisdictions then. As to where you
No, I think...
Depends where your money's deposited.
I think what it would be, in Thailand, for example, it's a bit like a few other places in Asia. If you pass away with assets in Thailand, the Thai authorities, I think, are able, if they choose, to go after your worldwide assets. It's a bit like the Philippines. The Filipinos, if they're domiciled in the Philippines, the Philippine authorities have the right to tax you on your worldwide assets. In practice, they haven't got the capabilities of doing that, and therefore they tend to limit it to the country where the assets are located. So, in terms of burial cremation, if you're claiming domicile in Thailand, you should say in your will, I wish to be cremated and buried in Thailand, as my executors choose. The job of the executor is to sort out your funeral wishes. So most people say, I don't want to be buried or cremated here or in Hong Kong. I do want to be, all sorts of requests that we get. But the The one clause of a will that's not legally binding is about funeral wishes. It's a wish. I wish to be cremated and scattered as my executors choose. When you die, your body becomes the property of the executor. They can do what they want to with it, technically. So if they chose to take you back to the UK and bury you, they could. It wouldn't create an issue with the tax authorities. But if you have it,
Except it would give you UK domicile.
no. If you write in your will, I want to be buried in Thailand, but your executor decides to take you back to the UK,
Yeah.
it's okay.
So if you're silent on it, then
Well, if you're silent on it, it's okay, but you should, to reinforce your claim of a non-domicile, write in your will, I wish to be cremated or buried in Thailand, if that's your intention. Not your intention, but your wish to be domiciled there. You should tell your executors what they actually should do.
That would be the...
So why is this important? This is important for tax because if you've got somebody, take me again, for example, born in the UK, if I was still domiciled in the UK when I die, my estate has to pay 40% UK inheritance tax on my worldwide assets.
It's actually daylight bloody robbery.
It is. So 40% tax on my worldwide assets if I'm still UK domiciled. So you can imagine, if I'm non-domiciled, if I'm successfully domiciled in Hong Kong, what does that mean? There's no estate tax in Hong Kong, it's a good place to be domiciled. But if I'm successful in being domiciled in Hong Kong, I only pay tax, or my estate only pays tax, on my assets located in the UK. Now for me, I've got no property, I've got a bank account with a few £100 and I barely have anything in the UK. So I might have no UK inheritance tax if I can show successfully that I'm domiciled in Hong Kong. So where you're domiciled is critical for how your assets are subject, or which of your assets are subject to UK inheritance
So
tax.
can you be domiciled somewhere where you're not living?
Yeah, good question.
very good point.
Yeah, good question. You can, actually, and for many years people would try and get away with that. You'd have somebody, we had a client who'd lived in Hong Kong for 15 years, and they were then posted back to the UK for work on a 2-year contract. And after the 2 years, their plan was to come back to Hong Kong. So they were arguing that their domicile had changed to Hong Kong. They were now being sort of forced to go back and live in the UK for 2 years. But while they were resident there, their domicile, their home, their long-term intention was to remain domiciled in Hong Kong. Now, a few years ago, you could get away with that, and they would accept that although you've become resident again, your domicile remains Hong Kong. There was a guy from HSBC, I think his name was Stuart Gulliver, for those of you who might have heard of him.
But he did the share price.
I think this is correct, where I say that he spent time in Hong Kong, not very long, a few years, and he tried to say that he was domiciled in Hong Kong, which he may well have been. He then moved back to the UK a long time ago, and whilst resident in the UK for many years, tried to claim that he was still Hong Kong domiciled, which was really, well, you know, come on, you've been here, how long have you been back here now? 8 years, but you're still claiming to be Hong Kong domiciled. So I think, primarily because of that sort of fairly high profile case, the HMRC changed, just a couple of years ago, changed the law so that, if you take me again, if I now am posted back to the UK for a year to write wills, I become resident. I'm not going to get into residency rules today, but if I become resident in the UK, I would at that point regain my domicile of origin. And therefore I'm taxed at
Whether
40...
you wanted it or not.
Correct, whether I
You
wanted
don't
it.
get a choice.
Even if I was going to go back for a year and I knew I was coming back to Hong Kong, I would regain my domicile of origin. And that means I'm subject to worldwide 40% tax.
Yeah.
If I then left and I came back to Hong Kong, I then have to spend 4 more years to get rid of that domicile again. So HMRC, they've really clamped down in recent years on people trying to get away with, well, I'm living here, but I'm not really domiciled there. Which again has big impacts on your inheritance tax as and when you die.
So how do they know? Should you be declaring you've got assets offshore?
While you're alive, you mean?
Yeah.
Yeah.
Good question.
So then, of course, you'll then talk to your financial planner and your tax advisors, and you'll say to them, look, I might move to the UK in the next 2 years, and what does that mean? Because you're going to regain your UK domicile. So there are things you can do. There are trusts perhaps and investments that you can put in place that can remain offshore if it's structured properly and if you've had the right advice. So that when you go back to the UK, some of those assets can be sheltered perfectly legitimately from UK inheritance tax. It's not the sort of thing you can plan, 3 weeks before moving back to the UK.
No, but if you're married to a non-UK citizen, you haven't got to declare this, have you?
At what point? Because the inheritance tax only applies when you've died.
Yeah.
So during your lifetime, HMRC don't really care what you're doing with your assets.
Only when you die, when I can't declare anything because I'm dead.
You're dead, and they're going to say, right, where was this chap domiciled? And if they decide you're domiciled in the UK, doesn't matter where your assets are, they're all subject to 40% UK tax. That then is an obligation of the executors to go through the right process to pay the tax and declare the assets.
So it's a legal responsibility on the executive.
Correct. Yeah, it is. Yeah.
Can you tell us, let's say you're living in Thailand, you plan to stay in Thailand, but you're a frequent visitor to the UK, for example, or you might have national insurance, or you might have a national health service card or something. What are the things you can do, to cherry pick, as you might say, to get all the benefits of being in the UK without actually any of the obligations, like spending less than half the year in the UK and things like that? Can you clarify that?
Yeah, in recent years, it's become very important to be aware of the residency rules. And
have they changed? They have changed.
They have changed. They're always changing. They have changed, and the main change has been what makes you UK resident. And it's not just if you spent 6 months a year, or 3 months, or 120 days, or an accumulation of time over 3 years, and it used to be all sorts of calculations.
Yeah.
But the main thing being, if you now start to spend more time in the UK, it's not just the length of time you spend in the UK. They'll look at your connections to the UK. Have you got a property? Not just have you got a property, have you got accommodation available to use? And that can create a tie to the UK, and that can mean you're allowed to stay for fewer number of days per year. If you're employed overseas, that's a tick, and you can stay for longer. If you've got kids at school in the UK, that's a tie, and it limits your days. And so, good luck with the residency rules, and it's this thick if you want to read it from the HMRC website,
Well, if you're retired in Liverpool, yeah.
If
Retired, then you can't.